Welcome. Today I wanted to talk about the Supreme Court and the recent rulings that have come out in the past week. The first major ruling that I want to talk about is a ruling on the student debt relief plan, which was a campaign promise that Joe Biden ran on. This debt relief plan would forgive $20,000 of debt to a single person, and it would lower the required monthly payments for anybody who had governmental student loans. Now, this relief plan wasn't a great solution. It ultimately didn't solve the greater problem of the cost of going and getting a higher education, but it was the best we have seen so far in our failures of US presidents. Since inauguration 3 years ago, Joe Biden has been trying to push through this plan and get it enacted in some sort of way. And in those 3 years, major banking corporations such as Sallie Mae and Navint have been fighting back. They have fought back so much that in those 3 years, they have spent nearly $10 million on political donations and lobbying to prevent this from going through. All of this effort and money put into this by the major banking corporations finally came into fruition in the past week. The Supreme Court decided that Joe Biden could not push through the student debt relief and that he had to go through Congress, a very long and arduous process. This decision by the Supreme Court shows their opinions on the matter of student debt and the state that it is currently in. This shows that they do not believe it is an emergency. They do not believe that people are suffering by this or that they need to help the people who are suffering. The reality of this is that 1 in 10 Americans who have student debt are defaulting, meaning they can't actually make payments on the debt that they have. This is a real problem that needs real solutions, and the Supreme Court doesn't believe that, or doesn't care about it. The second case that I wanted to talk about was on the subject of affirmative action and its legitimacy as a business practice. For those who don't know, affirmative action is a method for increasing diversity as a way to combat the systemic racism that minorities face every single day. Affirmative action can be seen being used not only in colleges, but also in any contractor of the government or subcontractors of the government. The difference between these two areas is that in colleges, it is not a mandate. It is often a practice that the colleges puts on itself as a way of self-regulation, where in employment, it is a federally mandated system. You've probably heard a conservative talking about how affirmative action is actually the systemic racism in modern day. This is a lie. And it's a very clever lie, where it appeals to that sort of very liberal ideology that a lot of the US has today, where everything needs to be treated with equality. To understand this, we can look at the COVID stimulus packages, where everybody received $2,000. That was really nice, and that was a great thing that probably helped a ton of people. But we can look at the effects of it and how it was implemented. For one person who makes $100,000 a year, it's not a lot. It's still nice to have that sort of cushion money, but it's marginal in respect to what they make and what they can live off of. But that $2,000 to somebody living in poverty who makes $20,000 a year, that money has a way larger weight to it, as opposed to the person making $100,000 a year. This is the fundamental difference between equality and equity. Equality provides assistance to everybody, whereas equity takes into account the backgrounds and the current situations of the people and gives help based on that. Equality fails because it doesn't take that into account, and it can leave people starving and dying because they received the same help as a person who doesn't need it. But if you take the help from the person who doesn't need it and give it to the person who does, that has a much larger impact than equality does. And this is the fundamental failure of the US liberal ideology where everything needs to be treated with equality. That doesn't work. That doesn't help everybody. That ultimately just upholds the current standards of society where people and minorities are constantly oppressed. This is where conservatives are able to sneak in the little lie because they can make it seem like one person is being systemically oppressed by something, when in reality, the other person is just being picked up. Like with affirmative action, it isn't that white people are getting kicked out of colleges, it's just that minorities are brought in more than compared to normal. And even though affirmative action has been a very decisive and hot topic, it has been in use since the 1960s, although it hasn't all been smooth sailing. 8 states have banned it since its first implementation. The pushback by conservatives even went so far that it came before the Supreme Court once in the past. In 2003, the case of Greta versus Bollinger came to the Supreme Court, where the validity of affirmative action on a nation scale was challenged. But in 2003, the Supreme Court decided that it was constitutional. But all of this effort put in by activists and legislators has now gone down the drain, because just last week, the case of Students for Fair Admissions v. Harvard ended, where the Supreme Court ruled that the use of affirmative action went against the Civil Rights Act. The irony of this, that multiple activist groups have pointed out, is that the Supreme Court has done nothing about legacy admissions. Legacy admissions is simply where the students or applicants who are children of past graduates are much more likely to get in than the average student. This process has been well known and been used since even longer than affirmative action. It's been seen being used in as early as the 1920s. Yet the Supreme Court does not hold the same sentiment towards that, because they likely took advantage of this system, and their children will likely also take advantage of such system. The final ruling that I want to look at is just another on the list. It is not original, it is not new, it's just a different minority that it applies to. The ruling I'm talking about is the case of 303 Creative versus LNS. This case is where Lori Smith, a marriage webpage designer, challenged her right to discriminate. She, as a business, cannot discriminate under the Civil Rights Act, but she wants to because she believes a certain thing. In this case, she's a marriage webpage designer, but she doesn't believe gay people should get married. So she wants to be able to discriminate against gay people simply based upon her belief system. This is not allowed in the Civil Rights Act. It says that all consumers should not be barred based upon race, sex, etc. And this directly goes against it. But in this case, the Supreme Court deemed that she can discriminate. She can legally discriminate with no repercussions based upon her belief. And the reason they are able to claim that it is her First Amendment to discriminate is because the Civil Rights Act does not explicitly describe websites. Because the Civil Rights Act was written in the 1960s, it doesn't know what web pages are to the extent that they are today, so it doesn't describe them. And this allows the Supreme Court to freely interpret and therefore legalize discrimination. The extreme irony of this is that this case does go against the Civil Rights Act, whereas affirmative action does not, but they ruled in two very opposite sides. They ruled in their own personal interest to uphold the current hierarchical structure of society. All of these rulings can be used to show how truly biased the Supreme Court is, contrary to what it and the government wants you to believe. But these biases and this inherent corruption doesn't stop there. And to fully understand the extent of how bad the situation really is, we must go on a more personal level of each of the Supreme Court justices and their own morally bankrupt decisions that they have made in their time as justices. Now, in the Supreme Court, you have 9 total justices that make up the Supreme Court, one of those being the Chief Justice. And out of those 9, 7 of them likely are connected to some very clear conflicts of interest or just blatant corruption by taking donations and trips with some very rich billionaires. Out of the 9 justices that we currently have, 6 of them have been nominated by Republicans, 3 of those being nominated by Democrats. Now, I'm not saying that Democrats are in any way better than Republicans, but it wouldn't surprise me at least to know that out of these 6 Republican nominees, all of them are tied to some sort of conflict of interest or just blatant corruption. And only one Democratic nominee has some ties to corruption. Democrats ultimately are not much better than Republicans. I mean, look at Obama. He massacred 4,000 innocent civilians over his time as president. That's not necessarily a good person by my standards. But there is some ideological lines that have some trends that are questioning. Now, the details of the corruption that the justices participate in are a much more interesting story. First, we can look at John Roberts. John Roberts is the Chief Justice at the Supreme Court, kind of like the head, per se. Now, John Roberts' spouse, Jane Roberts, is a partner of McRae Inc. McRae Inc. is a legal recruiter in Washington, D.C. This inherently doesn't have any conflict of interest or corruption present, but it does when Roberts decides to not disclose any of his wife's clients, meaning his wife could very possibly be a recruiter for somebody involved in a Supreme Court case. This is where the corruption comes in, because why would you not disclose your wife's clients if it doesn't have a conflict of interest? But the likelihood of it being a conflict of interest is very high when you choose to not disclose those conflicts of interest. Next, we can look at the oldest Supreme Court Justice, Clarence Thomas. Again, this has to do with spouses being in conflict of interest jobs. Thomas's spouse, Virginia Thomas, is a founder of Liberty Consulting, a legal consulting firm. This is a mirror case to Robert's spouse, where there is a very likelihood of Thomas's spouse working with clients who happen to be in Supreme Court cases. And again, Thomas does not disclose any of his spouse's clients, leading to a very high likelihood of there being a conflict of interest there, because why would he hide his wife's clients besides there being a conflict of interest? Also, his wife has been caught contacting multiple government officials, including Trump's chief of staff, trying to convince them to overturn the election. Her connection to the January 6th insurrection was so bad that she was forced to give testimonials in the January 6th case. Another very concerning connection for his spouse is that she was an executive director for the Heritage Foundation, a well-known, very extremely right-wing think tank. But all of this is very minor to the blatant corruption that Clarence Thomas himself participates in. You see, for 2/3 of Clarence Thomas's career as a Supreme Court justice, he has been in a business relationship with Republican billionaire Harlan Crow. He likes to claim that this is quite simply just a friendship. It's not. You can't be in a friendship with somebody without there being some conflicts of interest there, especially as a Supreme Court justice. This no longer qualifies as a friendship. This is a business relationship that he willingly participates in. He has so much willingly participated in this relationship that they have gone on vacations on his private jet, his private yacht, and he has even gone to his private resort where other well-known billionaires stay, leading to not only him being in a business relationship with Harlan Crow, but there is a high possibility that he is in business relationships with other billionaires. The fact that Clarence Thomas still holds a position as a Supreme Court justice is very telling of the sort of regulations and self-regulations that they uphold themselves to. The next justice I want to look at is Samuel Alito. Now, I would argue Samuel Alito is one of the more blatant ones who participates in a very blatant corruption similar to Clarence Thomas, where there are direct ties between some conflicts of interest and Samuel Alito. His first foray into the corruption comes to when he decided to go on a private fishing vacation with Paul Singer. Now, you can go on vacations all you want. The problem is that when the person you're going on this vacation with is a president of a hedge fund. Now, Singer's hedge fund was Elliott Investment Management. Now, EIM has been in a decade-long case at the time that Singer and Alito went on a vacation. And after this vacation, the case that they were in was ruled in 2014 in EIM's favor. The surprise of this all was that EIM was then rewarded with $2.4 billion due to the ruling of this case. This is a very obvious connection between Alito and Singer. Now, in this case, Alito did not sit out. He did not disclose his relationship with Singer. He did not do any of the regulatory things that the Supreme Court is required to do. Yet he was not punished in any way due to this very clear conflict of interest. The next justice I want to look at is Neil Gorsuch. Now, Gorsuch decided to get into the corruption game very early into his career as Supreme Court Justice. He got involved so early that it was a mere 9 days after he got instated as Supreme Court Justice. 9 days into his career, he decided to sell property to Brian Duffy. Brian Duffy is the head of Greenberg Traurig, a major law firm that since this selling of property has been involved in 22 cases before the Supreme Court. And in those 22 cases, Samuel Alito has sat out of 0 of them, even though he has connections to Brian Duffy, the head of Greenberg Traurig. He also did not disclose this selling of property until other investigative reporting found out. He has also been involved with Penguin Random House. Now, Penguin Random House is a well-known publishing brand, but it's also well known for donating to Supreme Court justices, and then those Supreme Court justices not sitting out of the cases in which Penguin Random House is involved with. For Samuel Alito, he has received hundreds of thousands of dollars in donations from Penguin Random House, in which Penguin Random House has been involved in one case since Samuel Alito's instatement as Supreme Court Justice, and he did not sit this out. Penguin Random House has also been paying another Supreme Court Justice, Sonia Sotomayor. Now, Sonia Sotomayor has received reportedly millions of dollars from Penguin Random House. And Sonia Sotomayor has been involved in 3 of the Penguin Random House cases. She has not set out any of them, and she has also not disclosed this business relationship between the two. The corruption doesn't stop there, though. It even gets more blatant for Brett Kavanaugh. You see, Kavanaugh likes to enjoy the company of government officials, so much so that he's gone to Christmas parties with said government officials. The exact government officials he's been known to party with are House Representative Matt Gaetz and multiple Trump affiliates, including Sebastian Gorka and Stephen Miller. both of the Trump affiliates have been giving testimonies in the January 6th case. These are just a great group of people to hang out with, especially when you're supposed to be a very impartial judge for the Supreme Court. Impartiality does not seem to come very easily for these Supreme Court justices, especially Amy Coney Barrett. The sad thing about Barrett is that she didn't choose to be original in any way. She just chose to copy Clarence Thomas and John Roberts because her spouse, Jesse Barrett, is a partner of South Bank Legal. Barrett's spouse has been quoted as saying that he specializes in white-collar defense. South Bank Legal also boasts to have clients virtually in every single industry, including 15 clients in the Fortune 100. Now, Jesse Barrett and South Bank Legal's clients have never been disclosed to the Supreme Court. Again, meaning there is definitely a conflict of interest there, due to the non-disclosure of any clients. Today, I just kind of wanted to talk about the sort of corruption that the Supreme Court likes to participate in. Ultimately, we have no say in how the Supreme Court functions or the regulations put onto them, a very sad reality that not only stems for the Supreme Court, but any of the government. In fact, this is just the sad reality of the US government and a lot of other governments that exist around the world. It's just important to know what's going on and what to prepare for. Thank you guys for tuning in to this video, and I hope you guys have a great day.